Texas instead of California. I'm going to try this and see if I can do. That worked. Okay. I'm on to something here. Order of all visitations. Originally, it was ordered that all visitations would happen with Baby W in Los Angeles, Orange, Riverside, and San Diego counties. On 1/16/25, John filed an RFO on the court's regular calendar, alleging the 1/15/25 order was wrong and needed to be corrected. The hearing on the RFO in 2B occurred on 3/17/25. That was the court date that she did not attend. Remember, she said she was tired and slept. My client, now again, this is Bree's attorney talking, right? So she says, my client was self-represented at this time. She did not appear, did not file a responsive declaration. Thus, as stated in the minute order, opposition not having been filed, attached Exhibit E, the court granted John's request and ordered for all of Bree's visits to occur in Texas. There is no proof of service on file of service of this order to my client. Per the file stamps on these next filings, on 3/24/25 at 9:46 a.m., John filed another ex parte RFO accusing Brianna of kidnapping Baby W with the exact same file stamp of 9:46 a.m., meaning, in her opinion, filed in the same e-filing envelope as the ex parte RFO. Was the findings and order hearing from the 3/17/25, i.e. the actual controlling order from 3/17/25. That was just wordy to say he did them together. It is well settled under California law that when a FOAH is ordered to be prepared, the minute order is not the operative order. The FOAHs. Remember, that's when it came out where people were saying, well, the judge didn't sign that order. That was just a minute order that was released. So was that in effect? Was it not in effect? We saw one that was signed by a judge, one that wasn't. So that's what she's battling here. One cannot be found to be in contempt of an order unless there is a valid and enforceable order at the time of the alleged acts were committed, which is why, you guys, I don't think, everyone keeps asking me if I think that she's going to be charged with kidnapping. I don't believe that she's going to ever be charged with that. I do believe that is going to play a huge part in the outcome amongst everything else she's doing. An FOAH is not an operative order until it is signed by the court. In the 3/24/25 kidnapping RFO, John includes the FOAH as an exhibit which is clearly unsigned by the judge, which his attorney e-filed at the same time of his emergency motion. The FOAH was not signed and entered by the court until 4/3/25, Exhibit F. John and his attorney filed this ex parte RFO using an extremely inflammatory label, kidnapping, despite full knowledge there was no signed order. I keep doing kidnap because that's how it's written in the thing. I'm not trying to mock or anything like that. That's literally how it's written. So I'm reading everything exactly how it's written. Okay. It's extremely important to correct a false narrative It is extremely important to correct a false narrative. Narrative being fueled online. it's her wording. She's trying to say it's extremely important to correct a false narrative before putting it out online, and it gets fueled. John's approach with the 324 kidnapping RFO, a label that has now caused this case's publicity to skyrocket and the narrative to spiral out of control, piggybacks off the messy procedural history, the lack of service on the 3/17/25 minute order, and the week delay in filing the FOAH after that hearing feel like bad faith moves, not innocent mistakes. In the emails between counsel and counsel that I attached on my last declaration, the court will note that I am called argumentative for bringing up these issues to counsel. Now, first of all, I would say